We'll continue our lessons for people who are going into the criminal justice system with this very simple video and article on plea agreements. It's super important to understand plea agreements because most cases get resolved by some type of a plea agreement. Not everybody goes to trial. I went to trial, which was a big mistake for me because I knew I was guilty. And I pushed the government to prove the case in a trial. It resulted in me getting a 45-year prison sentence and a much more severe outcome than otherwise could have been the case. Had I known more about plea agreements, I may have made a better decision. So make sure that you're spending time educating yourself and learning about these different nuances that follow once a person gets brought into the criminal justice system. So what are the basics of a plea agreement? Well, it is a negotiated deal where your attorney is going to negotiate with the prosecutor to get some benefits in exchange for a guilty plea. You will get some benefits, and the prosecutor typically will get some benefits. Those benefits may include they're going to drop some counts. It may mean they're not going to charge a family member in the case. It may mean they're going to agree to a lower sentence. Now, plea agreements, though, are really typically are just an agreement between the prosecutor and the defense attorney until the judge accepts the plea agreement. And so you really want to get to know the nuances of the type of plea agreement that your defense attorney is working with you on. One type of plea agreement that not all judges go for is called a Rule 11C1C plea agreement, sometimes just referred to as a C1C plea agreement. And this agreement is binding on the judge if the judge agrees to accept the plea, meaning if your attorney and the prosecutor agree that you choose to plead guilty, and in this plea agreement, they are going to agree that you will not get a sentence of more than, say, 3 years, 36 months, which I know seems like a long time, but in the federal system, that's not considered a very long sentence. But if they come to that type of a plea agreement, a C1C plea agreement, and the judge accepts that plea agreement, well, that means you know you're not going to get a sentence that's longer than what's in the plea agreement. On the flip side, sometimes people make a plea agreement. The judge is not bound by it. He respects that there is an agreement between the government and the defense team. But at the end of the day, it's the judge's decision, even on a plea agreement, on what sentence he is going to impose. Now, there's a different type of a plea agreement called a straight plea, which means you are just going to plead guilty and fall at the mercy of the court, in which case it's super important for you to be thinking about a mitigation strategy. And you don't need to hire some type of prison consultant or somebody who fancies himself as a prison consultant to do this. You need to invest your own time and energy and resources to figure out what is the best practice that I can take to start building a comprehensive mitigation strategy that doesn't only work with your defense attorney in preparation for sentencing, but also positions you for self-advocacy work once you get into the prison system and as you work through supervised release and try to get early termination. There's just a plethora of information that you want to learn. It's why we give everything away for free here on prisonprofessors.org. There's no question you can't ask. In fact, I'm going to share my screen with you right now to show you how to go get information. So if you visit prisonprofessors.org, you will notice this little section here at the bottom of the screen right there. If you click that little button, it's our little AI tool where you could ask, anything. Anything you want to ask, you could ask right there, and we trained this AI bot to try and provide you with information that will help you get answers to your questions. And I know that you're going to have a lot of questions if you're going into the criminal justice system. It's your job to learn as much as possible. And I know that sometimes people want an individual to kind of be a sounding board and give some type of guidance. I would just caution you if you're going to hire somebody who fancies himself a prison consultant. There's only one group I recommend, and in full disclosure, it's a sponsor of our nonprofit. That's my friend Justin Paperny, who runs White Collar Advice, and they sponsor an interactive webinar where you could ask your questions. You just visit, I think it's whitecollaradvice.com/nonprofit for members of our community, and you can register for the webinar and ask your questions. But for now, just educate yourself. So when you're going for a plea agreement, another term that you're going to want to understand is called a proffer session. Sometimes it's called a queen for a day. There are other monikers, but it's basically where you are going to go and meet with representatives of the government, probably an FBI agent or SEC or IRS or some government agency, along with a prosecutor, and you're going to have the opportunity to share, or you're going to listen to what they have against you, what you have to offer, and why you're a good candidate for a plea agreement. That's really just an information gathering session. I think your defense attorney would probably negotiate it, so anything you say in that proffer session is strictly for the purposes of the proffer session, showing what you know and what you can offer and why it makes sense for the government to offer a transaction, or potentially to try and persuade the government why you should not be a target of an investigation. It's just super important for you to understand as you're going through this process that by the time you get involved in a case, you should expect that the government has already invested quite a bit of time and energy building evidence and building a case in this system. And you're at a very big disadvantage, but your liberty is also on the line. And you need to understand all of the ramifications that come with a criminal charge. One of the big decisions that people have to make when they're negotiating plea agreements is cooperation. Are you going to cooperate with authorities and provide them with substantial assistance? There are ups and downs to that decision. I never make a judgment call on what somebody does. I personally made a really bad decision of denying that I had anything to do with the crime when I in fact knew I was guilty. I went to trial. I took the witness stand. I perjured myself on the stand and said I didn't do it. And it resulted in me getting a 45-year sentence. There's always a penalty that comes with exercising your right to a trial at sentencing, because the system will believe that you have no remorse, you're not accepting responsibility, and that may well very be the case. You may not want to accept responsibility for something that you didn't do. My role is not to provide any judgment on what somebody does, but it's to help you understand the nuances and the collateral consequences or the opportunity costs that come with every decision. If you cooperate with the government, in exchange for, as part of your plea agreement, the government may move the court with a motion known as a 5K 1.1, and you could learn more about this under Title 18 USC 3553 Section E, where the government can move to ask for a lower sentence, a downward departure, or even a variance from the guidelines in a manner that will result in you having less exposure. And the judges typically honor those 5K1 motions because they recognize if the government is advocating for you to get a lower sentence, the judge is typically going to support the government. But the cooperating with the government definitely requires you to be honest. You can't omit facts. You can't mislead. You have to be honest in that cooperation agreement, or you're going to lose your 5K1. And there are a lot of people that has happened to. They think that they can skate their way through one of those agreements, but they end up getting themselves in more trouble, and it really hurts them at sentencing. So if nobody has to speak to the government, but if you do speak to the government, just be honest. Because you're drawing a line in the sand and you're saying this is the path that I want to take. And if you are pushing for the lowest possible sentence, then that is one option that you might want to discuss with counsel and understand. There's a lot of fear of people that are going to prison that have a 5K1. I think that is a valid concern depending on the type of crime. I started my sentence in a high security penitentiary where I served the first 7 or 8 years of my sentence. And if somebody came into that environment with that 5K1 label on them, they're going to have a more complicated adjustment strategy than somebody that didn't have that complication. I didn't have that complication, which is one of the reasons that I probably had an easier adjustment when it came to interacting with other people in that population of about 2,000 or 2,500 people. So you do want to be thinking about having a very solid plan And it is one of the reasons that I really encourage people, be the CEO of your life. Identify success as the best possible outcome for you, and then create a plan, develop some priorities. What do you have to do first? And then develop your tools, tactics, and resources that are going to help you through the journey and get the best possible outcome. You want to make sure, if you're going to cooperate, you understand the benefits, which typically mean you're going to serve less time in prison, but you also want to understand the risks, which could mean a more complicated adjustment while you're in prison. That's not necessarily the case, but it is a potential that you have to consider. So that's why I always say you've got to define success first. What is most important in your life? Risks and the drawbacks of a plea agreement are that, well, once you plead guilty, you are effectively accepting responsibility. You're acknowledging that you did, in fact, commit this offense. And once you do that, you want to kind of go all the way and make sure that you are positioning yourself, that you get the full benefits, which is getting out of prison early. So make sure that you have a strategy to demonstrate that you're working to emerge what you've learned from this, how you identify with victims, why you're never going to be a criminal again, why you're a worthy candidate for an earlier release date, right? These are the things that you want to start positioning yourself to do. And again, I would encourage you to look through our website where everything is free. You want to click on that section up there that says profiles in the top right, and build yourself a profile that is memorializing everything that you're doing in your life. This is an essential component for self-advocacy later in the journey. And I really would encourage you to be learning about that strategy and using it not only to prepare yourself for the best outcome at sentencing, but also to position yourself for administrative relief much later down the line. And if you don't understand that, that's one of the areas where I would recommend you go to Justin's interactive webinars, where he could show you examples. I would love to say that I could talk to everybody. That's just not my role. My role is really in influencing macro changes and building more pathways for people to earn freedom. So just remember that every case is unique. Every individual is unique, and you've got to understand the strengths and weaknesses. You really want to understand your relationship with defense counsel, and I hope that you have a great relationship with your defense attorney, who is going to speak with you honestly, respond to your questions, help you through this journey, help you understand why it may make sense to pursue a plea agreement, or what costs come with not pursuing a plea agreement, which I'm going to discuss in a later video. So I would encourage you to always be honest with your defense attorney. Make sure you memorialize and document everything that you know. Do not omit anything, because your attorney can't really guide you unless you are honest, and the defense attorney, he or she, truly understands everything about your case. I made a really bad decision because I knew that I was guilty, but instead of even pursuing a plea agreement, I went to trial, and I paid the price with a very severe prison term that kept me incarcerated for 9,500 days. I always make 3 promises to you. I'm never going to lie to you. I'm never going to ask you to do something I didn't do. And I'm never going to charge you a penny for anything that's on prisonprofessors.org. Everything is free. We just want to encourage you to make the best decisions possible. Don't get suckered into some salesy charlatan who masquerades as an expert, and he only served a year or so in a single camp and doesn't really know anything and didn't really do anything. You are the CEO of your life, and I know you can make the best possible decisions. My name is Michael Santos. I'm the founder of Prison Professors. I do hope that you will subscribe to us on social and get our newsletter, which you could get just by entering your email. And that way I can keep you up to date on the advocacy work that I am doing, in hopes that you will be using this as an asset or a resource to help yourself. Be cool.